All right, so in today's video, we're going to actually go over YNW Melly's case today and what was addressed in court regarding his witness tampering trial. Because this hearing wasn't about guilt or innocence. It was about how the state says the communication happened. I know y'all like, wait, what? They put all that out there today? Yeah. And once you hear what the prosecutors say, it's going to get wild because they're going to explain what moved through the jail. They say they got it on video. They got a whole bunch of things. And you'll understand exactly why this case is being handled separately from the murder trial. Let's go.
Instructions. I did, in fact, do it where the first three counts would go first, and then the count to the gang activities would be bifurcated. So, Ms. Buckler, you're moving to do that yourself?
Yes, Your Honor.
Okay, so then based on that, without objection from the state, that one's going to be granted. The trial will go forward as to counts 1, 3, and 5 only for purposes of what the jury sees. I'm going to call those counts 1, 2, and 3, but on my information, it's count 1, tampering with a witness in a capital felony, count 3, solicitation to commit tampering, and count 5, conspiracy to commit tampering.
And Judge, I typed up an order.
Oh, okay, let's see what you got.
I showed defense counsel.
Okay, Mr. Finley, no objection to this?
No, I need a motion to bifurcate gang enhancement as to counts 1, 3, and 4. The state has agreed to forego enhancement on those counts, and I think they prepared an order, a DD order, and have no objection to the order as it's drafted.
That's correct, Your Honor. We're going to go on the gang enhancement on those other counts.
All right, so you're not gonna seek it at any point?
No, and the only caveat is if somehow the door is open, gang evidence could come up, but otherwise we're not going forward on the enhancement of the trial.
Okay, so hypothetically, if the defendant got convicted on one of those counts, you're not going to want to present any additional evidence, and you're not going to be asking for that enhancement to be included. Okay, so no objection to this order, Ms. Buckley? Okay. So then, otherwise, that one by the agreement of the parties is granted. Give me 1 second.
YNW Melly just got a big old W, and how you can get a big old W too is boom, hit that goddamn QR code right there. Win some money. Start your Monday off winning some cash. I know New Year. Y'all want to make some paper real quick. Scan that QR code or hit Fast Cash in the description link. And there you go. I'll take you there. You can win some dollars. Nobody's screaming this is a scam like Drake and Aiden Ross. The only complaint is how much money they're not getting. But you're only playing for like 30, 40 minutes, bro. Get in the game. Let's continue on. Yeah, so what she's really doing is conceding. And I got to pull this one up because I want y'all to understand how crazy this part is, right? So what she's doing is she's conceding because she doesn't want to prove what the hell a gang is, right? And by Florida statute, right? We'll just show y'all right here. Florida statute says, in Florida, a person deemed a criminal gang member if they admit to membership or meet 2 or more specific criteria, including adoption of gang, dress signs, tattoos, identified by law enforcement, parent, reliable informant, association with known members 4 or more times, or physical evidence / admission of membership. These criteria outlined in Florida statute 874.03 help identify individuals involved in criminal gangs. So then the criteria goes on to further say, for a gang member must meet 2 of these. Says admission, admits to membership in person or on social media. Identification by others, identified as a member by a parent, guardian, spouse, or reliable informant. Appearance adopts gang-specific style of dress, hand signs, and tattoos. Association associates with known gang members. Observation observed with known gang members 4 or more times in custody. Requires willful association. Evidence identified by physical evidence or an informant whose information is corroborated. And then he goes on to say context and relatable definitions. Criminal gang, an organization where 3 or more people whose primary activities include committing crimes, sharing a common name or symbols. Criminal gang association, a person who admits to association or meets any single criteria for gang membership. So basically, what I believe, here's what I really see. They trying to hold on to that for the next trial, for the trial in 2027. Because right now, it doesn't really make sense because you'd have to say that Howard is a gang member and then they would have to prove everybody else. So you'd have to prove Cortland Henry's a gang member, you'd have to prove that Howard is a gang member, and then you have to prove YNW Melly is a gang member. That's just a whole lot of time to really prove a whole bunch of nothing, because unless this was gang, don't really matter. Just gonna keep it off there.
Okay, so as to, this is the defense amended motion, amending paragraph number 1, the YouTube videos by 1090 Jake, you don't want to use any of those unless the defense makes it relevant, so.
Correct.
Okay, so that one is granted then, with that understanding. As to paragraph 2, yes, ma'am.
Judge, may I just ask that should the issue come up as to whether or not it would be used as the coach sidebar, if there's some belief that it's or something like that?
Yeah, that's fine, and if you need me to send the jury out to have that discussion, I'm happy to do that too. It's not a problem. Okay.
And the same with paragraph 2?
All right, state your same position as the TikTok video of Neek Baby, Neakbaby, is that correct?
Correct, Your Honor. I informed the defense that we would not be playing the video. I might use a screenshot because of the username, which was part of the investigation as to identifying users on the book. But we would not be playing the video.
Okay, so same ruling as to paragraph number 1. As to paragraph number 3, statements by James Howard. Yes, ma'am.
So, Your Honor, provided in discovery are literally hundreds of phone calls of James Howard to a whole bunch of different people. And, but none of the calls appear to have anything to do with Demons. There appears to be a call where he indicates to someone he knows Melly, quote unquote, or he needs to talk to Melly, quote unquote. But there is nothing that indicates there's any conversation from James Howard to somebody about that would be relevant to the charge of tampering recordings.
State, you want to use these statements?
We do plan on using the statement, not the irrelevant calls, Your Honor, but in the warrant affidavit, PC affidavit, it does spell out that there are numerous calls between James Howard and one of the defendant's girlfriends, Erin Burnett. There were, I believe, 26 calls made to Cortland Henry, calls to Erin Burnett. There's some calls that discussed ASAP Rocky with Mr. Henry, which is part of the tampering case that we plan on presenting. So there are calls that are specifically laid out within the warrant affidavit and the PC affidavit that state which calls we would likely use.
Okay.
All the other calls are irrelevant.
Okay, so for this one, I'll defer on it. Again, each side can make whatever appropriate objection they need to at the time of trial. Again, I'll repeat, if it's an issue that I need to send the jury out to have a more thorough discussion with the lawyers, I'm happy to do that. If the parties aren't in agreement on some of these, I don't know any other way to do it. I don't know what the evidence, witnesses or testimony are going to be at the trial. I would need to hear what that is to determine if this evidence is admissible, if it's hearsay, if there's a hearsay exception, if it's relevant. So as to paragraph number 3, I'm going to defer that statements by James Howard. Paragraph number 4 is phone calls between Cortland Henry and Junvia Molina, which is Junevia Molina, Molina. Yes, ma'am.
I believe the state is agreeing with this.
Yes, sir, and I informed the defense this morning that we don't plan on using those calls unless there's a reason I find a call that explicitly has something that shows the conspiracy is still ongoing. I would let them know ahead of time, but as of right now, no.
So, some YouTube video by 1090 Jake, he gonna have to explain that, bro. Y'all go get on his heels. Go spamming Jake, you need to explain this one. Yeah, since you were to not go look up my November 2023 Young Thug YSL freaking interrogation video that I dropped years before the last year, get on Jake heels as well. But, they saying they wanted to introduce all calls, and this is where the state often wins with some of these attorneys who can't handle it. But I want y'all to notice something, and I'll point it out. Maybe y'all can point it out too. Bruh, they just trying to let all calls in. They like, nah, we need to stop, screen this, screen that. So you're going to see a lot of jury instructions of go ahead and head out the jury room while we debate this and debate that. And I'm going to be honest, I'm not really liking that. Me personally. But the judge later reveals Wednesday he got stuff to do, so this is scheduled to go for the 21st of January. So there's that part. But other than that,
so that one is, again, granted based on that caveat. Number 5, hearsay statements contained in writings and phone calls of Terrence Mathis. Yes, ma'am.
And Your Honor, I put this in a motion simply to really alert the court. I think that this is going to be an issue I'm sure you're going to want to defer on. with regards to the sufficiency of the evidence of a conspiracy. Mr. Mathis is not testifying as a witness. To the extent to which his statements or writings are admissible, I assume the state would be relying on co-conspirator hearsay. And of course, the law is very clear that conspiracy has to be proven prior to the admission of co-conspirator hearsay. So I recognize this is a difficult issue for the court to rule on ahead of time without hearing what evidence may be presented. But I think it's important that it is raised at this point so that we're not jumping into hearsay, having objections in front of the jury, all of that. So I really am wanting to put the court on notice that this is a concern of ours and one which I think the court is going to have to address.
This right here is, and I think all you guys will agree, this huge. She's saying, bruh, before y'all even bring in certain things, you must prove the conspiracy. So before we can even have a ton of things come in, before we even get this started, bruh, you have to prove a conspiracy even existed, which makes a ton of sense. But I think what they're trying to believe for the judges, and this is the judge's belief, I probably should have said that differently. What I believe that they're trying to do for the judge is give him of the belief of, okay, this makes sense, this doesn't make sense, so that every single time he has to go, all right, good. And it's rare that the state is going to go 10 for 10. So my belief is this. The judge has to eventually kind of ask himself from the rules in which Ms. Holt is doing is basically this. Yo, 1 is good. 2 is good. 3 is good. 4 is good. 5 is good. 6, take 6 out. 7, 8, okay. 9, take that out. So if I get them to score 80% out of 100, that's a W for Melly. Regardless of how somebody who was messing around with their kid and only won off of a technicality wants to spin this, I'm still going to remain neutral and unbiased. Because there is a huge L that does happen at the very end of the video. And I'm going to have to be the one to point it out. Because over here, we're fair, square, obvious, and honest. Let's go.
Okay, and you want to use this?
We do, Judge, and I think you will disagree on this, but the state's position is that the writings that we intend to use, the calls that we intend to use, while it is maybe Terrence Matheson's voice on the call, it is actually the defendant's words, they're his letters. We do have jail video we intend to present where he is, and it's all explicitly stated in the warrant affidavit and PC affidavit, where the defendant is holding what appears to be a kite, which is a letter, it passes jail, goes under the door, another inmate takes it, passes it through the wall, another inmate grabs it on the other side of the wall and presents it to Mr. Mathis, who then walks over to the phones and makes a call to put on Henry. And so that's
Okay.
really there. I can provide Your Honor with the calls that we intend to use to make rulings ahead of time, but I do think there are multiple layers to these calls. The first layer, not even being co-conspirator statements, I would say they're not being convicted because they're not asserted, but it's a statement of legal significance, aka an offer of fact, therefore not hearsay. And then the other statements that would not fall under that hearsay, non-hearsay ruling would be the co-conspirator statements. And I do believe there is sufficient evidence, either just spelled out in the affidavit or PC affidavit, to explain that there was a conspiracy going on. Obviously, under the evidence standard, we do have obviously the verbal acts that we do not consider hearsay as part of the conspiracy. We have James Howard calls to Mr. Henry. We have payments made by Mr. Demons to Mr. Mathis' attorney, George Perez. We have the defendant's phone privileges revoked. We have texts between Mariah Hamilton and Geneva Molina. We have other calls Mr. Mathis made to Portland Henry about Mrs. Barnett. We have Ms. Hamilton not showing up for trial or deposition. And we have that jail video.
Now this right here, that video you just saw, that's where the how it all happened. This is what makes it a whole entire crime. But I'm going to ask you guys this one. And I mean this with all sincerity. If what is proven to be said is true, do you believe that that's going to give this person a life sentence, meaning YNW Melly? Does that sound like that's going to happen? Or does it sound like, from what I said before, the max he's going to get is 15 on this? And it's going to start the day of the alleged crime, which is April 2023. So I hear people, but this ain't no damn witness tampering where there's firearms involved and all this crap. It has to be pretty goddamn violent for witness tampering to actually be a life sentence. But regardless of that fact, if this is true, this ugly. Because I drop a kite, aka just a letter, and my people pick it up, give it to somebody else. They make a call to Borland and him. Because you got to remember, Borland was at home during all this. He was under the ankle bracelet, like we like to say in the hood. But he's under GPS monitoring. So that's where Cortland got his doggone case kind of like thrown out a little bit. Because at the end of the day, this is how it looks. The state's saying, we don't need any of that shit. We got it on video. We got phone calls. We don't need a damn thing. We don't need YNW Portland to come out and say nothing. We don't need James to come out and say nothing. We don't need no James Howard for shit. We got this one in a bag. And that's where it starts to look bad for Melly. But y'all remember what I told y'all about Carrie Hall? This where the money gets made.
Yeah, last word on this one, Corey.
Thank you. About 80% of what was mentioned appears also to be hearsay. I'm not sure what statements of pleading significance mean in terms of the exception to hearsay rules or operative facts. But it does seem like it is pointing an issue we're going to have to address as we see how the evidence comes in. I would remind the court that the dates alleged are April 10th through July 22nd, 2023. And the state has been very cooperative with providing discovery, so I'm sure we're going to get this information. The videos we have at this point appear to all have occurred after the dates charged in information, but that might just be how they came across. So we'll have a chance to hopefully look that up and see what the content is. I know from the court order that we have to have exhibits.
Well, just so you all see them.
Yes.
You don't have to turn them into me.
I know, but that will give us a chance.
Yeah. Okay. All right. So I'm putting up number 5. Hearsay statements contained in the writings and phone calls of Terrence Mathis. I'll defer on that one, and I'll give you a ruling at whatever time it arises during the trial, based on whatever objection either side thinks they need to make. So.
Judge Finlay, I'm sorry, the majority of paragraph 5, and what we've argued about, is a lot of state statements. So we would really need a ruling prior to a jury being sworn, because obviously that would affect whether or not we go forward. So if I may, maybe we can put together some calls for your honor to listen to, and we can have another hearing date where it's argued prior to the jury being sworn.
I mean, if you want to turn something over to me and have me reviewed ahead of time, as long as they have it, and they don't object to it, I'm happy to do that. I've never heard any of these calls. I've never seen any of these writings, so this is all in a vacuum to me.
And just so, the argument really is the conspiracy has to be proven, not prove the hearsay. So having the phone calls aren't going to necessarily give the court the information needed to determine whether there's independent evidence of the conspiracy so as to allow the phone calls that are hearsay. So I think that almost requires an evidentiary hearing.
The state's arguing that some of these calls, the state's within the calls, are not hearsay.
Yeah, listen, I'm not quite sure how I can do that before the trial, but I mean, I'll try to craft some time for you, and this isn't something you want to do tomorrow.
I would have to get all the calls together and but I could try.
Okay. Well, as to that one, I'm going to defer on it when we get done with our discussion today. If you want me to schedule something in the future, understanding that I'm starting, as I'm sure you all know, I'm starting another capital case on Wednesday, so I might have a limited amount of time, but I'll do the best I can for you. On my case on Wednesday?
I might be able to.
Well, I think I'm going to decline that invitation at this point.
No, it's scheduling purposes, but it's not anything to do with the actual case.
Okay, well, press pause on that. Number 6, the resolution of Cortland Henry's case and the resolution of Terrence Mathis's case. Yes, ma'am. All right, you're not going to introduce any of this
Correct.
stuff. All right, so that one's granted. We're not talking about how they resolve their cases.
The judge is going to allow a quote-unquote per basis, per whatever, on each and every one of these. Meaning, and it's Terrence Mathis. I don't know why I said Howard. I was thinking of Paul Howard, but whatever. Terrence Mathis and Cortland Henry. This is where the money is made. None of that shit that they got, plea deals and all of that stuff, is getting freaking brought in. But I want y'all to notice in this last clip, I want y'all to really notice how Carrie Holt is a damn shark. She's really whooping ass right here because the judge is noticing the same thing I'm noticing. They being very friendly with Carrie Holt. Very. To the point of, you didn't see the statements Buckaloo and none of these other cats react or interact with any lawyer like they did with her, which means her balls got to be as big as grapefruits because she's over here secretly saying, yeah, I'm challenging all of this shit. Every damn thing. You're not really getting nothing in. And the way that the state is behaving with her, they kind of, I don't want to say scared, but either they trying to walk her down and let her get into a damn nice posture so they can hit her with that KO, or she just walking them down with jabs and getting ready for that setup. Because listen to how this shit ends. There's more video, and I'll get to it because tomorrow we got court as well, so I don't want to bore y'all with too many particulars. But listen to how this shit goes.
Number 6, the resolution of Cortland Henry's case and the resolution of Terrence Mathis's case. Yes, ma'am. All right, you're not going to introduce any of this
Correct,
stuff.
once again, caveat is what we
All right, so that one's granted. We're not talking about how they resolve their cases. 7, any mention of the counts of the information that only charge Terrence Mathis and Cortland Henry. Yes, ma'am. You guys aren't? Okay. So, Ms. Buckley, if we get that far, and you've tried plenty of these cases with me before, we would need a dummy information for the jury, which would only contain, since we're bifurcating the 3 counts that would be for their consideration, and you can remove the numbering, just the language, and just show it to defense, and just so they're aware. I give each juror a copy of the jury instructions, and I would give the jury as a whole this single dummy information, which just contains the actual language that's in the paragraph of the information, nothing else. So there would be nothing going back to the jury regarding the counts that do not include Mr. Demmons. Number 8, the fact that Mr. Demmons is charged with a capital felony. Yes, ma'am.
And it would be our position, Judge, that the fact that the capital felony is also a sentencing enhancement, and that it is prejudicial to Mr. Demmons for the jury to know he's under indictment for murder, when it is not necessary to the charge itself. The allegation is not an element of the offense, it is a sentencing enhancement. Punishable by life, and the court can take judicial notice of this, or obviously stipulate to this, should there be a conviction on the list.
State your position on that is?
Well, Your Honor, at first I was a little confused with the wording of it, and I did bring that up to counsel, because the title says the fact that Mr. Demmons is charged with capital felony, so I was in agreement, obviously, not to talk about sentencing, or that it's a capital felony, and the reason like for that. But the fact that he is charged with murder is the underlying offense as to the tampering, and that is completely relevant to this case, to the serious nature of the case, as to why a witness might be tampered with. You can't try a case in a vacuum at this point, and it's very typical for the underlying charge to come in and for the court to take judicial notice of it and just to discuss basic facts of the case in order to establish the tampering without making it a feature of the case.
Well, I'm looking at 21.10, the standard jury instruction for tampering with a witness pursuant to 912.22, subsection 1, which is exactly what Mr. Demmons is charged with. To prove the crime of tampering with a witness, the state must prove the following 3 elements beyond a reasonable doubt. And the third element is the official investigation or official proceeding or offense or violation of the condition of probation, parole, release, affected, attempted to be affected, involved in investigation or prosecution of a, and then they give me a list of choices, and one of those is the capital felony. It's an element of the crime. So, over the defense objection, I think that one's going to be denied. It's an element of the crime. So, the defense's objection is duly noted, but I certainly can't prevent the state from introducing evidence of something that they're required to introduce to prove their case.
They knew that motion was bullshit. They knew that damn motion was bullshit. I knew the motion was bullshit. You can't sit up here and say, oh, well, we don't want to say the actual crime he's charged with because it could prejudice the jury. They snuck that shit in there. And the judge damn near went for it. The judge had to go straight up and read the freaking book. He had to, 982.60 says this. I ain't seen that happen since, what the hell is his name? Glanville with Adrian Love. I ain't seen that shit since them. If this is what's going to continue to happen and the judge is going to continuously just have to look at the book, they're going to have that same book. He said, oh yeah, it had an A, B, C, D, and this qualifies for Melly. Bro, they knew that shit when they came in there. They knew it. But the way that they handling her lets me know she's a damn fighter. So I'm looking forward to seeing how this shit plays out because in my opinion, here's what I really see. They're going to try to mess around and go, hey, it's not really witness tampering, really. It's really more so he was trying to prevent her from coming to the trial so that she doesn't face all the scrutiny and all the death threats and all of these things like all of these other individuals, right? And then I think their strategy isn't necessarily to beat the witness, to beat the whole entire charges. I think it's just to beat the witness tampering part and go with the conspiracy and all of this other shit because there's talks of money, there's talks of all this shit. If I'm Drew and Carrie, I'm throwing YNW Portland under the bus. I'm throwing Terrence Mathis under the damn bus. Their stuff ain't coming in. They're not coming in. Now, they do got to play it pretty slick, pretty close. They do have to do that. Because just like, I won't let certain shit in unless y'all do it. But I'm finna cast a shadow of doubt like, nah, think about this. She didn't just work for YNW Melly. She didn't work for Melly at all. Really, in all honesty, she really worked for Borland. And Borland might have sought approval for YNW Melly, but they can't say that because then that part brings in Melly. But at the end of the day, I think what they're going to do, I ain't never talked to Drew Phil in a day in my life and don't want to. Unless he want to raise some money for, Ceddy Nash getting his law degree. Nah. I don't. I see it as this is going to get shifted to two other people and not YNW Melly. This, to me, is probably going to look like a shakedown to not have Mariah come in by the mother because the mother's text messages get real eyeball, and it's a lot of money that's talked about. And if they could do that, because she's going to have to come in and say, I don't recall. She's going to come in, plead the fifth. Then she'll get forced immunity like Kelsey got. And a lot of y'all finna get mad I said that shit. I just seen some moron just say, oh, bruh, Kelsey this. I said, bruh, she had forced immunity. Like Lil Woody had forced immunity. Oh, her bodyguard. Yeah, but it was Tory Lane's bodyguard that was in the car, not Kelsey's. Shut up, Ceddy Nash. I got you. But y'all, what you think? Are you one of those people who gonna believe the PDF who says it's all done, it's all hell over here? Why would he go ahead and go ahead and say all of these things to try to get her to not come in? Or y'all the mindset of he was trying to protect her to not come in and have her life turned upside down? My position is this. His ass was trying to control shit, regardless of who came in. I wouldn't want nobody coming in. Period. I don't give a damn who it is. I don't want nobody. I don't want no witnesses coming in. I don't want you to help the state in any capacity to get me convicted of shit. I don't care what it is. I don't care if I'm accused of cutting your grass and you had a grandson and a granddaughter who was there, or a son and a daughter who was there, and basically they say they see me do it. I'm about to try to get them not to come through. Period. Whether I did it or I didn't do it. But hey, it is what it is. Y'all, let me know y'all thoughts on this one. And if you like content like this YNW Melly shit, all these case files, especially with these rappers, and the best news for this shit, hit that subscribe button today and hit that like button for us to the algorithm. And let me know y'all thoughts on this one. Other than that, click right here to see how NBA Youngboy had a goddamn mole in his damn circle. Click right here, or click right here for the playlist. And tomorrow, we'll get the video all done way faster. I'll catch you on the next one.